The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oh yay, oh yay, oh yay. All persons having any manner form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, thank you. We'll open the case. Well, how many counsel we have here? I think we should just have two, Mr. Brown and Mr. Green. All right. We'll call the case of Brown Enterprises versus Affiliated FM Insurance. And Mr. Brown, I don't know if you're related to David Brown or not, but
I am not, Your Honor.
Okay, so this is just a coincidence. We'll hear from you first.
Thank you, Your Honor, and good morning, Your Honors. If it please the court, my name is C. Thomas Brown. I'm with Silver and Brown. I'm counsel for David S. Brown, but not related to David S. Brown. This is an appeal involving an interpretation of a first-party insurance policy, and as such, it's reviewed de novo by this court. First-party insurance, as the court is aware, is a contract containing a promise by an insurer to pay its own insured if there's a non-excluded loss to covered property. In this case, we have two causes of loss, both of which are covered. We're not talking about excluded losses. Both flood and broken water main are covered by this policy. The insurance policy in this case is 81 pages long and is located at Joint Appendix 1126 through 1207.
Mr. Brown, you just said something that probably goes to the heart of my problem with this case, that you seem to make a big distinction between water coming from the broken water main and water coming from the rain flooding down. And the combined water, you allege, caused the damage to the foundations of your two establishments. From what I can see, the policy defines flood to include both. It basically includes overflowing water onto areas of where water is not normally covered, whether caused by rain or man-made or whatever. And explain to me why it's important to distinguish between water coming from the broken main and water coming from the rainwater draining.
Well, two issues, Your Honor. The first is the efficient proximate cause. And here the efficient proximate cause, according to William Barnes, who's the geotech.
No, please answer my question. In terms of the policy, okay, as I understand the policy, if a truck runs down a fire hydrant and the fire hydrant floods for 2 days onto a neighboring property and damages the property, that's a flood under the policy. And well, the policy defines flood, whether it's caused by man-made devices, whether it's caused by nature. It's a broad statement. It's a water, unwanted water, overflowing water. And so even you look at the dictionary, it fits it, but your policy definition is even broader. So the question I have, what difference does it make for the argument that where the water came from? You suffered water damage. Water damage is flood. And the question then is, how does the policy handle that?
Okay, there are two issues, Your Honor, and let me unpack those a little bit. When we're looking at flood in the policy, number one, you talked about the policy definition of flood. If we look at the sublimits, because this is a sublimit case, the sublimit, when it defines flood as a sublimit, does not use the bolded term flood. That is, when it uses a term of art throughout this policy, and if you go to the sublimits or Joint Appendix 1134, the term flood is not bolded, okay? So it doesn't reference the policy definition of flood. It does bold the term annual aggregate, which is policy definition. It does bold the term occurrence, which is a policy definition, but the term flood.
That doesn't gain you very much because the policy doesn't embolden unnamed locations. It doesn't cover errors and omissions, off-premises service interruption. All of those are defined terms. You gain nothing from the notion that...
Understood, Your Honor. I'm pointing that out because that is one issue in the case. Second issue is this, Your Honor. If we read the definition of flood, and we got to read the definition in total, that's the key.
Well, right? What do capital letters have to do with it?
Bolded. Well, when this policy uses, throughout this policy, you'll see capital letter, not capital letters, they're bolded, Your Honor, bolded. You'll see bolded terminology used throughout the policy. Every time a bolded term is used.
Explain what the bolding is?
Excuse me?
Does the policy explain what the bolding letters mean?
I don't think it expressly does that, Your Honor. However, it does throughout the policy use.
They could work that in there somewhere if they were going to.
In fact, Your Honor, even if we look at the term flood, right, if we go to the definition of the term flood, and that is found at, let me see, Your Honor.
It's 1191.
1191, you'll see.
Overflowing or breaking of boundaries of natural or man-made bodies of water.
Okay,
and water flowing from them and so forth.
Let's start with the very first language. It says flood means flood, all right, and then has a list of terms. And it says regardless of any other cause or event, whether natural or man-made, contributing concurrently or in any sequence. So flood, what it does is a flood remains a flood regardless of whether wind caused the flood, whether the flood was impacted by some other cause. Flood stays flood, but it doesn't turn the other cause into a flood.
It's not a cause. We're not causing a cause. We're looking at the definition of flood, and you suffered water damage, which was, you alleged in your complaint, caused by flood. That's the only thing you allege in your complaint. Your damage was caused by flooding. Now, what caused the flooding would fall within natural or man-made bodies of water.
But, Your Honor, broken water.
Excuse me, sir.
A broken water.
Sir, excuse me just a minute. And the policy defines the flood waters as those that are natural, the rainwater, or man-made, broken pipes, broken fire hydrants, the neighbor's property flooding. In other words, unwanted water overflowing or breaking the bounds. Now, if you look in the dictionary, that's exactly what the dictionary says. It says overflowing of water, especially over a land that's normally dry. Now, the question I have is, we're not talking about the cause at this point. We're causing what is a flood and whether your water damage is flooding.
The water from the broken water main, Your Honor, was never surface water. Surface water is a flood.
What difference does that make? It's flooding. Flooding is unwanted water, overflowing water from whatever source.
Your Honor, not all water is flood water.
No, it has to overflow, and it has to overflow onto places that are normally dry.
That's correct, Your Honor. And a broken water main is not surface water. It's not rising water.
It doesn't have to be surface water.
Your Honor, I'm just looking at the definition of flood in the policy.
You're not gaining much traction because the flood is defined in the common sense term. The policy wants to make clear that it doesn't matter where the water comes from. It's unwanted water over what is normally dry land that causes damage.
Your Honor, it's over dry land. And if we look at the list, Your Honor, everything in this list is a surface water event. That is waves, sea storm surge, rising water, surface water.
That list where it says flood means flood, is that where you are?
Yes, Your Honor. Right following flood means flood. So flood means flood, and then has semicolon, surface waters, and it's not that. Rising waters, it's not that. Storm surge, it certainly isn't that. It's not sea surge. Wave wash, waves, tsunami, tide or tidal water. The release of water, it's not a release. It's not above ground, Your Honor. It's not rising, overflowing, or breaking.
The water came up over the ground and channeled down the street from two sources, from the rainwater flowing off and from the broken main. And that water came and hit the foundations of your properties, washed out the soil, and damaged the foundations. But by the time it got to your property, it was all on the surface.
No, Your Honor. Actually, none of it was on the surface by the time it got to our property. A large channel formed in front of the building. That is, it washed out half the street and the entire sidewalks. If you look at the video,
the pictures were taken from people standing above the ground, looking into the eroded portion of the street facing the property. Now, you say that's not flood water?
No, Your Honor, it was water that fell into a channel. The water main broke one store up in front of our two buildings. Right? It washed away underground to the soil. The soil collapsed, the sidewalk collapsed, the street collapsed, and it created a channel. That channel is what allowed the water to reach the foundations of these two buildings. The water from the storm, the water main break, never made it to the surface. Our expert, Your Honor, said, look, without the water main break, we have no damage. He points to the 2018 flood, a flood that happened 2 years later. No water main break, no damage at all. It was a bigger storm, a bigger flood. And Your Honor,
could I ask you this question? Assume that whether it's bolded or not is not persuasive, and I think Judge Niemeyer has underscored the fact that you have a plain language construction problem based on that definition, assuming that applies. Don't you also have a problem in addition to that with respect to the regardless clause, establishing what within the trade is what's known as the concurrent causation clause? And as I understand it, at least in Maryland, as the district courts in Bow, Hamilton Jewelry, and McWhorter have construed almost identical clauses as establishing concurrent causation. I read those cases, those clauses are almost identical to the one here, and I'm having a hard time following your argument that somehow this is different than that. So set aside the plain language argument you're making. You still have this problem, and I don't follow your argument that this is not an anti-concurrent causation clause.
Okay, Judge Cullen, and this is where it's important. The two causes here, and let's just call them cause A and a flood, right? But the two causes are both covered. Right? So if flood was excluded, the anti-concurrent causation language would do exactly what you said. That is, a flood remains a flood even if some other cause intervenes. Okay, for example, let's say wind. A wind.
Right. You're hypothetical about the hurricane wind causing the storm surge and then both contributing to the damage.
Correct, Your Honor. So wind's covered, flood's not, but flood remains a flood regardless of the wind. The wind doesn't change the nature of flood.
And wind doesn't become a flood.
But under this language, the wind doesn't become a flood. That is, what this says is flood means flood regardless of any other cause or event. And that it's very effective as in an anti-concurrent when flood is excluded. Here, Your Honor, flood is covered. Flood's covered, broken water main are covered. They're both covered events. The problem is, under this policy, we're dealing with sublimits. What sublimit applies? The policy tells us what happens when two deductibles apply to a single occurrence by two different causes. It doesn't tell us what happens when two sublimits apply to a single occurrence.
Can you answer my question specifically, though? How is this causation, this regardless clause, different than the one that District Judge Mott's considered in Bow, the clause in Hamilton Jewelry, and the clause in McWhorter?
Because in those clauses, Your Honor, was an exclusion, and they weren't turning the second covered event into a flood. They were just saying the flood doesn't change its nature as an excluded event because of a concurrent cause.
But doesn't your argument, essentially render that regardless clause as surplusage? A flood is a flood, right? Stops there.
Well, that's what it says. It's flood is a flood, semicolon. Now, flood cap, bolded is a flood. And I think what it says is, Your Honor, we don't care if some other cause or event caused the flood, wind, or let's say a dam breaks because of corrosion. The flood still remains a flood, despite the fact that another cause, which is covered, would create coverage under the policy.
And a sewer backup is a flood. If the sewer backs up so the water goes over dry places, it's a flood. And the damage caused by a backup of a pipe that's plugged up is a flood.
If it floods onto the surface, I would agree, Judge Niemeyer. Because a flood is the inundation of normally dry land by surface water. And if you look at this, that's typically what a flood is. This is a broken water main, subterranean, completely underneath the ground. Your Honor, the water
completely. The pictures, the water surfaces. As a matter of fact, you allege it. It's all throughout the testimony. The experts the water combined from the water main and from the rain, combined and pounded the foundation, washed out the street. And that's all on the surface of the street, digging that channel.
No, Your Honor, it's below the surface of the street. That's the problem.
Oh, so the street stayed holistic, and the water got it from underneath?
Well, no, the street collapsed, Your Honor. The street collapsed.
Okay, and then where'd the water go?
Then the water went into the channel that was created by the broken water main. So, Your Honor, if in the 2018 storm, there was no broken water main, street didn't collapse, water runs down the street, there's no damage to the two buildings.
Well, you had a flood, you just didn't have any damage.
We didn't have any damage in the exact
This time
same.
you had a flood again, and you had damage.
The first time we had damage, Your Honor, I see my time is up, but.
Right. All right, well, you've got some time on rebuttal. Why don't we hear from Mr. Green?
Good morning, Your Honors. Bryant Green, may it please the court, Bryant Green on behalf of the affiliated FM insurance company, and I'm here today to ask this court to affirm the district court judgment and apply the plain and unambiguous terms of the policy, nothing more and nothing less. This court should affirm the district court's judgment for two reasons. One, the policy's supplement for floods to unnamed locations caps this loss at $50,000, and two, there was only one occurrence here. Interestingly, in this case, after having enjoyed being rescued from the application of a specific flood exclusion for property that's not even listed on this this policy in the first place, David S. Brown seeks to have its cake and eat it too by avoiding the limitations applicable to the express terms under which it claims coverage. Now, initially, we focused our attention at page 1134 of the joint appendix, and the question that I would submit to my colleague is, if the $50,000 supplement doesn't apply here, when does it apply? There could be no clearer case as to when it does apply. And interestingly, I'm hearing for the first time today that this isn't a flood because it's not in bold. That argument wasn't presented to the district court. The district court, rather, David S. Brown argued to the district court that the flood supplement does not apply because all of the errors and omissions, off-premises service interruptions, unnamed locations, and supply chain coverages must apply together simultaneously. Apparently, David S. Brown has abandoned that argument now, and we see for the first time that because the language isn't bold. But what we haven't talked about yet is just above that, in the third paragraph, it says, quote, when a limit of liability applies to a location or property, such limit of liability will be the maximum amount payable for all loss or damage. Additionally, the term annual aggregate is bolded, and it says when the phrase annual aggregate means the company's maximum amount payable during any policy year. That's regardless of how many floods, how many contributing causes, and we just saw a holding to that effect in the New York University versus Factory Mutual case. In there, it was a claim by the insureds resulting from Superstorm Sandy, and they incurred upwards of $1 billion in property damage, and the insurer, an affiliate of my client, affiliated FM, applied a supplement just like the flood supplement here. And the court in that case, they said that the clear language is dispositive in FM's favor. Even if the faulty workmanship permitted floodwaters to wreak havoc on NYU's facilities, the resulting losses fall within the policy's definition of flood. The exact same logic applies in this case. You could even just extract the words NYU and insert David S. Brown, and the exact same analysis would apply. And that was just affirmed in July by the Second Circuit Court of Appeals. The other point that I want to make is there's been an assertion that this policy specifically covers flood, and that's true with an asterisk. This is a large property policy that covers I believe it's $750 million. And in order to claim that $750 million, you have to show, one, that there was a loss to a piece of property covered under the policy, and two, that the loss was not excluded. Now, the policy does contain an exclusion for flood. You find that at page 1163 at the joint appendix. And there's been no assertion for a claim under the all-risk coverage because, one, this specific property isn't listed on the declarations, and two, the flood exclusion would apply to the all risk coverage. Now, the policy also has several additional property damages coverages, and those are at page 1158 of the joint appendix, where certain classes of coverages are brought back in. And to the limited extent those coverages conflict with the exclusions of the policy, the exclusions don't apply. So here there are two applicable exclusions. One is, or two applicable coverages, 115 for flood at page 1163, and two unnamed locations at 1169. Now, independently, by themselves, there's no coverage under either one of those property because, for instance of flood, it does negate the flood exclusion, but it's still not a named location under the policy. Now, two, for unnamed location, the policy brings back a certain class of property, and the purpose of these kind of coverages are, we recognize that David S. Brown is a large property developer, and they don't need to go straight from the closing table when they buy or sell a property to their insurance broker and incur the risk. So we provide unnamed locations to some extent, but only when those two coverages combine do you get the coverage that David S. Brown is seeking in this litigation. Now, in order to accommodate the risk that one, affiliate is insuring properties it doesn't even know about, and two, it's doing so for flood, it does so at a reduced limit. And you see that at what we've been discussing here at 1134, the sublimits. Moving on to the actual definition of flood, my opponent suggests that the regardless language actually limits the definition of flood as opposed to expands it. And I think Judge Cullen hit the nail right on the head referring to the anti-concurrent causation clause. In fact, I'm impressed that you cited the Hamilton jewelry case that was decided after our briefs just recently. But what the anti-concurrent causation in this definition says is all water losses are going to apply to this loss. And we could get into a high-minded philosophical debate about what is a flood, but we don't even have to do that here. I'd note that at pages 18, 25, and 30 of David S. Brown's brief, and also in the reply, he says, or at page 18, 25, and 30 of the brief, and also in the reply, he says the entire loss was caused by the water main break and not by flood. That is the exact opposite of what all the testimony has been in this case. His own expert says, quote, the severe erosion was noticed, quote, concurrently with general flooding. Similarly, the same expert says there was a concurrence of two events. And at page 816, the question was, okay, so it's water main combined with flood that caused the foundation walls to fail? Answer, yes. That is the plaintiff's own expert. Actually one of two experts. The other expert, Scott Bradley, at 1405 of the appendix, says, sitting here today, my opinion is that that it was a combination of water from the flood and water from the water main. There's no dispute here that this property was flooded. In fact, Kara Brooke Brown, the managing member of the two LLCs at issue in this case, was posting on the internet saying that in 2016, her commercial investment properties on Main Street in the historic center of Ellicott City were completely destroyed by flood, and that's at 657. So we don't even need to get to the question of parsing apart the plain and unambiguous language of this policy, even though I'd submit that that is also dispositive in affiliated's favor in this case. The plaintiff's witnesses themselves concede that this is a flood. When there's a flood, even if it combines with other losses, the annual aggregate is $50,000. And then one point I just did want to address, even though it didn't really come up in my opponent's argument, is the definition of occurrence. What I would submit to the court is that the definition of occurrence in this case has three elements. One, there has to be all loss or damage. Two, it has to arise out of or be caused by. Three, an event of physical loss. Specifically with the second element, the words arising out of and caused by are separated by the disjunctive or. So if occurrence is a synonym for cause, as the plaintiff submits, that would mean the arising out of is superfluous. It doesn't exist. Now, in the briefs, there's been discussion of the World Trade Center case. That's probably the most popular case on number of occurrence issues.
Mr. Green, if we find that the aggregate sublimit in the flood definition applies, isn't that determinative? I mean, do we need to reach the issue of whether there's one occurrence or two, like the district court did?
No, you don't. You don't. the sublimit is dispositive. But it is also, for the reasons stated in the brief, affiliated's position that there was only one occurrence in this case as well. But I don't believe you must reach that decision in order to rule in affiliated's favor. Truly, that's all the points that I've prepared for today. I'm comfortable submitting on the brief.
Thank you, Mr.
Thank you.
Mr. Green. Mr. Brown. You're muted, Mr. Brown. There you go.
Sorry about that, Your Honor. I just unmuted. And let me start in reverse order. I'd point you to the Joint Appendix 1391, which was the testimony of William Carnes, the only geotechnical engineer who testified. And he was asked, without the damage caused by the water main, the flood flow would have been channeled to the middle of the street. Did I read that correct? I was reading from his opinion. I said, what did you mean by that? And he says, answer, it means that without the water main break, which destroyed the equilibrium of the soil against the foundations, the flow would not have been channeled against the foundations, and subsequent damage that was observed in 2016 would not have occurred. And I said, let me ask you this way. Had there been no water main break in 2016, would the damage that you observed to 8227 and 8231 have occurred, the extensive damage? And the answer is no, it would not have occurred. So without the water main break, there would have been no damage to this building. And Your Honor,
I think everybody seems to concede that, maybe, but the question is whether that's relevant to anything. In other words, the question is, water pounded the foundation, and water washed away the street, washed away the sidewalk, pounded the foundation, and caused damage. The pictures show enormous vacancy in front of the foundation, with all the soil and sidewalk and street washed away.
correct.
Now and it was done by water, and it was done by water caused by two sources: the rainwater and the broken main. That's what everybody seems to agree on, right?
That's correct, Your Honor.
So now the question is that combined water pounding the foundation, washing away the soil, the sidewalk, washing away the street, and pounding the foundation, is that flood damage?
And Your Honor, I would submit it's not flood damage because it is not surface water. This was all subterranean water. Let me go at it this way, Your Honor. If we look at the sublimit, there's no question sublimits apply.
Just a minute, policy includes surface water, but it also includes water from a backed up sewer, and which is subsurface water. So that isn't key. The key is whether we have water causing the damage when the water is normally not, it's normally a dry place. And the policy covers it from just numerous angles.
Your Honor, if the backup of the sewer results in sewage being ejected, water being ejected above the surface, I agree. That becomes surface water, it becomes a flood.
Well, this came up to the surface too. That's all the pictures show: the water, the whole wash away, the foundation's exposed, the street's gone, sidewalk's gone. The water's had to come down and wash all that away, pounding the foundation.
And it resulted.
Everybody, whether it's newspapers, laymen, or experts, all call that a flood.
It resulted from the if you will, the water main break itself. But let me go at it this way. The sublimits, and by your way, Your Honor, there is a sublimit that applies to unnamed properties. It's $100 million sublimit. That's the one that we say applies. Insurance company says no.
In order to get that, you have to conclude that there was not a flood.
Well, Your Honor, that's what the district court concluded. She said, remember that
policy says that
the sublimits are on a per occurrence basis. And the trial judge said, look, I disagree. It's the occurrence was not flood. The occurrence was not broken water main break. The trial court, I just said, the record reflects one discrete event of physical loss or damage. The foundations of the Main Street property was destroyed by water. Two causes appear by all accounts to have contributed to the one discrete event: the water main break, which created or exacerbated a channel near the Main Street, and the floodwaters. Having concluded that the occurrence was not flood, was not water main, the result is, under this policy, that you apply the sublimit that applies, which would be the unnamed property, not the flood. The flood may have been the cause of the occurrence, but the sublimit is defined by the occurrence, not the cause of the occurrence. And Your Honor, I would suggest that unlike the deductible section of this policy that says, look, if we have two deductibles that apply to one occurrence.
What if an airplane hits the top of a dam, knocks out the dam, the airplane negligently piloted or whatever, knocks out the dam flows down and floods properties. Is that a flood or is that an airplane accident?
Well, remember, Your Honor, if they're both covered, just like in this case,
no, it's important to categorize it because
Your Honor, it's a flood because it's all surface water.
You'll have to let me finish the question, okay?
Sorry, we're here.
Yeah, it's not a question of. It's a question of characterization whether the occurrence is an airplane accident or flood damage, and if it's flood damage, it fits one portion of the policy. If it's an airplane accident, it fits another. If the airplane instead had hit the house, it's not a flood. If it hits the dam and causes the water flow, I assume you would say it's a flood when it destroys the houses and the establishments.
Your Honor, I see my time's up. Would you like me to answer your question?
Please do.
Okay, so I apologize. But yes, Your Honor, in that case, the broken dam would cause an inundation of normally dry surface, right, the regular land, with water. It would be a flood. And it would be under the definition of flood in this policy. It would be covered because it's expressly one of the items that's listed, one of the itemized examples of flood. And that would be, it says, the overflowing or breaking of boundaries of natural or man-made bodies of water. That would be the breaking of a boundary of man-made water, a dam would be a man-made boundary that's made. So, Your Honor, I would just suggest that in this case, having found that the loss was not an occurrence of flood, was not the occurrence of water main break, trial court should have applied the unnamed property sublimit.
And that would be $1 million?
It's $1 million, Your Honor.
And would it be $1 million for each house or
it
$1
would,
million for both?
It would be $1 million for each house, Your Honor. The insurance company conceded that in their depositions.
Yeah. Okay. Thank you very much. Yeah. As you both probably know, it's our practice to come down and greet counsel in the well of the court. And thank you for your arguments and wish you a good day and all the rest and invite you back. We do all of that. We just can't shake your hand.
Thank you, Your Honor.
We hope you come back and visit us. And thank you for your argument.
I had my first argument with you back in the 80s when you were sitting by designation, Your Honor.
Oh my gosh!
Up in Baltimore.
Thank you very much.
Pleasure being in front of you, Your Honor.
Yeah, very good.
Sounds like Judge Niemeyer's been here a long time.
Well, he was there as a district court judge at that point, Judge Cullen.
Mr. Brown is very young.
You've been a lawyer for a long time.
Too long, Your Honor. I agree. Thank you.
Well,
Here.
Good job. We'll proceed on to the next case. Thank you. United States versus Dote, and Mr. Carpenter, I guess you begin.
Thank you, Your Honor. Good morning. May it please the court. I'm Robert C. Carpenter here on behalf of Donald Dott, a 78-year-old businessman who's running a telephone business in Costa Rica called Callmaster. He was convicted and sentenced to 9 months in jail for providing phone services that were used to perpetuate a sweepstakes scheme by a man named Rosenberg. I'm here to ask that you vacate the convictions and the sentence here. And so asking, I do recognize the high burden that I have, the heavy burden that I have for the conviction to be overturned. The case law is very clear that the court will see the evidence light most favorable to the government here. But this is one of those rare cases where the court, where there is not substantial evidence to support the verdict in at least 3 different ways. First, there was a gap in evidence that connected the victims of this conspiracy to the Rosenberg conspiracy. Number 2, there's a lack of substantial evidence that the victims are over the age of 55. And 3, there's lack of substantial evidence that Mr. Dott had the criminal intent to engage in conspiracy in aiding and abetting for those charges. And there's also some sentencing issues to cover today. And so there's a lot of issues.
Let me ask you, as a preliminary question, is there any, are you taking any exception to the notion that while Mr. Dott didn't engage in the actual discussions of fraud with the victims and didn't design that whole program, didn't select the method of doing it, he did support the operation with a very highly necessary phone service, changing phone numbers, phone locations, and he was aware, apparently, that they were moving from place to place. He heard conversations, he commented on them, and he even reported about FBI information. So that as a general matter, whatever is imputable to Rosenberg, as a general matter, would be imputable to him as a participant, a person who's substantially aided the operation.
I believe I would agree with that, Your Honor. Not maybe all the facts you cited, but certainly if he was convicted of conspiracy and aiding and abetting, and the elements were met for that, he could be liable, as the government says, for the substantive charges. I don't believe that's in dispute today. I do want to start with talking about the Rosenberg scheme and how it's not really different than all these other schemes that were happening in Costa Rica. There's lots of evidence that these types of sweepstakes schemes were very common in Costa Rica. You had Agent Quattlebaum, the lead agent, say in Joint Appendix 942, there's a lot of telemarketing fraud in Costa Rica. And I'll list a number of sites from the record on page 14 of my brief where everybody else agrees to that. In fact, you have co-conspirators here who branched off and started their own sweepstakes fraud using the same scheme that Rosenberg had. And of course, it gave you tons of other case sites, both in district court and other district courts with the same scheme. So, but there's a gap in evidence here connecting these victims to the Rosenberg scheme. Certainly there are victims of a scheme, and certainly Rosenberg's and his co-conspirators were engaging in this type of fraud. But there's a lack of evidence here on that. And that's admitted by the government's lead agent, Agent Quattlebaum. He didn't know whether all the victims sent money, for example. He admitted that on page 962. He didn't bother to contact the victims. He said that on also 962, 959, and 960. He also admitted that the conspiracy or the money could have been sent outside the conspiracy. That's Joint Appendix 961, 960, and 961. He didn't even confirm that the receiver of the money actually received it. And even if he did, there's no evidence he did so as part of the Rosenberg scheme. So there's a lack of evidence connecting this scheme, the Rosenberg scheme, to these victims. Additionally, there's no evidence to show that there's the callmaster numbers that were given were used to call these particular victims. What are the numbers that were used to contact these victims? Well, we don't know. We don't know what numbers Dott provided to Rosenberg and his co-conspirators. That's not in the record. So there's a lack of evidence also connecting Dott and the numbers he provided to the co-conspirators, to the victims. He was also convicted of a charge where there's an enhancement.
When you say there's a lack of evidence, do you mean lack of direct evidence rather than circumstantial evidence?
No, I mean when I say lack of evidence, I mean lack of substantial evidence for that standard in this court. There's not enough substantial evidence to connect Rosenberg to these particular victims.
And Judge Cogburn acknowledged that the evidence wasn't kind of thin on some cases, in some parts of the case, didn't he? But,
well, I don't remember that from the record.
Jury's entitled to inferences and things like that too.
Yeah, they are. And again, the court has limited scope of review. It's a tough standard for me to meet here, but there does need to be some evidence for the jury to base their verdict on. And I don't recall Judge Cogburn saying that at trial. I did cite many examples that Judge Cogburn said, classifying these VoIP services as fraud when in fact they're not. That's what stuck out to me with Judge Cogburn. But with respect to the
Mr. Carpenter, let me ask you this. With respect to the first issue you raised, which I agree with you is a kind of a critical link, that these victims sent money to the Rosenberg sweepstakes versus another sweepstakes in Costa Rica. And you make a specific objection about the so-called Quattlebaum exhibits, 27 through 32 and 35. And as I understand that objection, and you have to unpack it, but essentially there's, as I count, there are 17 wire fraud counts across 15 victims. And as I understand your argument, only 5 of those victims testified at trial. 3 of those, Ms. Vadgama, Ms. Fisher, and Ms. Dittman, through their testimony, couldn't necessarily link the money they sent to Rosenberg through a common runner like Mr. Gutierrez or otherwise. And then you have 8 other victims who didn't testify. And as far as I can tell, there's no other evidence but for this summary exhibit 28, where you have kind of the victim and sender information and the corresponding Quattlebaum exhibits. So your argument is those were improperly admitted as hearsay exhibits. Government says they weren't offered for their truth. My question for you, if that's the only evidence as to those wire fraud counts for those victims and they weren't offered for their truth, where are we?
Well,
first of all, do you think they were offered for their truth? I mean, they say yes. It's background. It's why the agent did what he did.
I very much disagree with that point. These were offered for the truth. These were offered to show that these FTC complaints were of actual victims and that he's able to link those to the Rosenberg scheme through the testimony of Rosenberg, not testimony, excuse me, through the debriefing of Rosenberg.
And I guess my problem, to the extent it may be a problem, is why couldn't the government have asked Rosenberg directly when he was on the stand, show him exhibit 28? Do you recognize this victim? How do you know that was one of your victims? So the issue is that they backdoored it potentially, did it indirectly. The agent said, well, he told me that in a proffer, or I went on the FTC database and I got a name, therefore this is a victim. I do think, I agree with you. I think that was admitted for the truth of the matter asserted, and there may be an issue with respect to some of these wire fraud counts for these victims who didn't testify, and there's no other evidence linking them to the conspiracy.
And I would add that Rosenberg called these victims by purchasing lead sheets from people. These lead sheets were physical documentation with these victims' names on it. They could have, as he alluded to, put Rosenberg on the stand and had him testify to those lead sheets and say these were victims. But again, there's no evidence of that. They didn't do that. And that's particularly true with his age of 55 count. They have to prove that there's 10 or more victims over the age of 55 in order for that count to happen. They don't have the ages of more than 10 at all. They didn't even bother to contact the victims. And so I think that count is an easy one for the court to throw out for that reason. There's no substantial evidence of these people's ages.
But isn't there that summary exhibit, and again, this gets into Quattlebaum, where there's certainly more than 10 who where the occupation is listed as retired, and yet Rosenberg testified that most of them were elderly, and I believe other co-conspirators did as well. And then you had 5 actually testify at trial. All that together, I think, permits a jury to conclude that you had 10 or more, doesn't it?
I disagree. I mean, this is a matter of statutory interpretation. And the statute is very clear that it has to be over the age of 55.
Yeah, but if somebody says, I was dealing with somebody who was retired and elderly, those 2 words together, and has a list that is much longer, has numerous people in that category, isn't that sufficient circumstantial evidence?
I would argue in response to that who are they? Who are the 10 victims who were over the age of 55? Who are the 10 victims who were elderly? Who are the 10 victims who are retirees?
Yeah, but if you have a list of 50 or 60 or 100 or whatever the number is, and they all list as retired, and Rosenberg says these were elderly people, sure, you can question whether somebody at age 55 thinks himself as elderly. But I would think that circumstantially you would get at least 10 out of that list. Your argument, I suppose, is we didn't pick the particular 10, maybe.
Well, I would argue elderly is a inherently subjective term.
It is. I'm combining it with retirement too, because retirement occurs sometimes at 55, but I think traditionally it's usually older, 60, 62, 65, and that's sort of a common sense approach, and it may not be sufficient, but I hear what you're saying.
Yeah, I think you understand that argument. The third sort of lack of substantial evidence argument concerns the specific intent issue with respect to Dot. And the government acknowledges he didn't have the specific intent to commit these crimes, that they get there through conspiracy, aiding and abetting, or willful blindness. And I would argue here that with respect to conspiracy, there's no agreement to commit a criminal act. All Mr. Dot did was agree to provide the same services at the same rate to Mr. Rosenberg and his cooperators to testify. He just provided us.
Let me just change the facts just a little bit. Let's say this is a mafioso that everybody knows is a mafioso and is doing illegal work, and he's a subcontractor providing essential phone service for the operations of the mafia. And he chuckles with them and he knows what they're about. He basically says to himself, I'm not involved. I'm not doing the mafia stuff, but I recognize I'm helping them in a critical aspect. Is that enough intent?
Well, it's not, I don't believe it's enough to rise to I think what you're alluding to is willful blindness. And that's what the only question the jury had was with respect to that instruction. So it's clear they considered this willful blindness instruction. And that willful blindness.
I don't know, it's willful blindness. He actually knows. He didn't turn his head. He did his job, but he knows he's aiding and abetting illegal conduct. Not only aiding and abetting, but in a very essential sense. The whole operation needed the reformulation of telephone numbers, the movement of numbers, the telephones, the installations, the breaking down of them and putting them back up. And if he knows that operation is illegal and he's helping it, I think he personally, I read the record and I read his allocution and I read a lot about him because I think this is a very tough case in terms of a personal situation. This man lived a life as clean as a whistle. And here he thought he was isolating himself from the illegal conduct by not actually doing it, even though he knew he was helping it. That's a sort of a street assumption. I'm not involved. But as a matter of law, I would think if he knows exactly what they're doing, he knows he's aiding them, he knows his work is important to them, don't we have a legal problem of excluding him from the conspiracy?
Well, what does he know? He knows that there's...
Well, that's a factual question. I'm assuming, I get in my hypothetical, I'm assuming he knows it's mafia. He knows that the mafia doing, and so then we transfer it to this case and we get back to my initial question is, was there a lack of evidence that he was aware of what was going on?
Yes, specifically, he wasn't aware that mail fraud, wire fraud, money laundering, those specific things were going on. Certainly, I think it's fair and like most able to the government that he had knowledge of some kind of shady dealings. I think there's an example where he overheard somebody impersonating a federal judge. You know, that is a crime under federal law. So there's knowledge of that crimes commission, but there's not knowledge of these specific crimes for which he was convicted of. And I know I'm out of time. I do want to talk about the sentencing issues, but I can do that on rebuttal or different. Or I can do it now, whatever the court would like.
Yeah. Why don't we? You can pick that up on rebuttal. And I think, at least with respect to one, I think the one involving the defendant representing himself as a government agent seems to be a pretty clear challenge. But why don't we hear from the government, and we'll get back to you, Mr. Kane.
Good morning, Your Honors, and may it please the court. Daniel Kane for the United States. I'd like to cover each of the issues addressed in my colleague's argument, including addressing the court's concerns about connecting the substantive counts, and I think the concern, Judge Niemeyer, you just alluded to with 2B1B9A. But I think it's important to begin with a quick recap of the evidence establishing Mr. Dott's understanding that this was an unlawful scheme. That's Mr. Carpenter's third point. The question is, what did he know? And I think it's important to drill down a little bit on what did he know to make sure this court understands that Mr. Dott was properly convicted of these conspiracy counts. So right from the beginning, when Rosenberg hired Dott, he told him he needed.
Tried the case.
I did not, Your Honor.
Okay, go ahead.
Right from the beginning, when Rosenberg hired Dott, he told him that he needed phone lines with DC area codes because his employees in Costa Rica would be calling from the US government. And he added that he would need to change the phone lines and move offices when things got, quote, hot. Dott then visited the call centers at least 8 or 9 times by his own testimony, more by other witnesses' testimony. And he overheard the pitches that the callers gave, including notably David Fairchild's, in which he pretended to be a federal judge, prompting Mr. Dott to joke, "You're looking mighty fine, Your Honor." Rosenberg also testified that Dott promised to forewarn him if he received any inquiry or subpoena into any of the phone lines. And importantly, Dott knew all the characteristics of the business, that he was paid in cash, he had no contract, that Rosenberg used an alias in his communications, that the call centers moved every few months, that they constantly changed phone numbers, that they were located in houses, not offices. Then if you fast forward to after the arrest in this case, Mr. Dott asked Fairchild not to mention him in interviews with law enforcement. And all of that, by the way, is apart from the evidence of the associated call centers, which includes evidence that Christian Serp, during the lifespan of the conspiracy, told Mr. Dott when they're doing an analogous scheme, quote, "What we're doing is a little shady," and that Mr. Dott told Laitano to, quote, "stay away from the Rosenberg call centers." So all of that, I think, overwhelmingly establishes Mr. Dott's knowing participation in the conspiracy. And because he joined the conspiracy with the intent to further it, he was responsible for the reasonably foreseeable substantive offenses committed in furtherance of it. Just want to make sure that the court is totally clear about the evidence supporting the conspiracy. And unless the court has any questions on that, I can turn to some of the substantive counts that Judge Cullen in particular was discussing with Mr. Carpenter.
Just a short note, because there are a lot of counts. My concern is similar to Judge Cullen's, and I'm focusing on counts 9, 10, 11, 14, 16, 23, 25, and 31. Those are the 8 counts where nobody testified, and it relied exclusively on this testimony of Quattlebaum. And not only that, your brief gives it about 2 sentences of support.
I'm sorry about that, Your Honor. Yeah, let me try to.
You don't need to apologize. There may not be much there.
Well, let me try to walk.
And Mr. Kane, before this will probably be helpful so you can address it all at the same time. Miss Badgama, Miss Fisher, you have 2 Miss Fishers, the one with an SCH, and then Miss Dittman. They did testify at trial. My problem with them is it's very vague. They, 202 area codes. Mike called me and I sent money to Costa Rica. That doesn't mean it went to the Rosenberg conspiracy. And then you have the ones Judge Niemeyer identified. I can't find any other evidence linking those wire transfers other than these exhibits. So let me ask you this question. Are you arguing that Exhibit 28 was not offered for the truth of the matter asserted?
Yes, Your Honor. Let me just make one point. Just Ms. Dittman did testify that she sent money to Mr. Ferrat Gutierrez. To answer your question, yes.
All right. So if that's the case, yes, her count in my mind is not problematic because Rosenberg testified about his role. Okay. Thank you.
That's right, Your Honor. Yes, Your Honor. I think we are arguing, and I think I can take this holistically to address Judge Niemeyer's question and your question as well, Judge Cohen. Let's begin with the testimony that Agent Quattlebaum gave. He testified that the investigation all started with Rosenberg. Rosenberg identified some victims and schemers, some phone numbers, and some hallmarks of the scheme. For example, the use of the DCRA, the Department of Consumer and Regulatory Affairs. The case agents then searched an FTC database for those names, those numbers, those hallmarks of the scheme, and then checked those results with Rosenberg and the other co-defendants, corroborated that evidence with Rosenberg and the other co-defendants, used those names that they discovered either through the names that Rosenberg had provided or the FTC list to query the Western Union, MoneyGram, and USPS databases. So what they're doing is, and those are of course admissible business records, and those exhibits are.
Yeah, but what about Rosenberg's testimony to the Quattlebaum out of court testimony identifying those?
So those statements, Your Honor, were never admitted. The government never.
No, they're not admitted, but they may be necessary.
Well, I think they were logically necessary to the investigation, but I don't think that those statements were admitted for the truth of the matter asserted.
It's hearsay, isn't it?
Well, I don't think so because
Quattlebaum's testimony. If Quattlebaum's testimony identifying that list to Quattlebaum Rosenberg's testimony pointing out to Quattlebaum which are involved. And then Quattlebaum makes a list from that and says, this is what Quattlebaum, he essentially is saying, this is what Quattlebaum told me.
Right,
How does that support a conviction?
I think it supports the conviction, not because it was entered for the truth, but because it was correlated.
Well, that's even worse. If it's not entered for the truth, there's no substantive evidence at all.
No, Your Honor, I think it was. I think it's the substantive evidence is that the names that Rosenberg identified, or the names that Quattlebaum and the other case agents were able to identify from Rosenberg's information, appeared on the admissible business records. It's that overlap. So the fact that the government agents introduced admissible business records and then queried those databases, those admissible business records for the information.
It's the connection. The connection gives it probative value. If that's not there, right, it's got no other purpose. And my problem is, if Rosenberg, if they could go into the jail and ask him, is this your victim? Is this your victim? And is this your victim? They should have done that when he testified. That's the cleaner way to do this. And for whatever reason, they just said, oh, we met with him and he provided these links. I'm having a real hard time with the argument this wasn't offered for the truth of the matter asserted. I'm not buying that.
Well, Your Honor, I don't think that.
Well, even if it was, then there's no evidence.
No, Your Honor, I don't think so. I don't think that's the only basis, because Agent Quattlebaum also testified that he spoke with Rosenberg and co-defendants after, that the case agents spoke with many of the victims, attempted to interview all of the indictment victims, and interviewed many of the victims to corroborate the information, to validate the querying of the MoneyGram, the USPS, the Western Union business records. And so, Your Honor, I do think there are connections other than the bare fact of Rosenberg having identified.
You in your brief, you identified just what you're saying, that he created this list, but all he got to was a list of wire transfers with recipients who picked up money in Costa Rica. And then you say this in your brief: Quattlebaum then reversed the search, running that list of recipients coupled with the potential recipients listed in the initial list through the same database, which yielded a longer list of wire transfers. He basically relied on his information with respect to other call centers and said, I'm familiar with them, and excluded them, and then assumed that the remainder belonged to Dote.
Well, that's right, Your Honor. He excluded based on his own experience. And that is another reason. That's not the only. But he didn't. And then he didn't just assume that the remainder.
Let's assume he knows all the call operators. He knows all the names. I mean, we're talking about thousands of names from these various call operators.
Well,
and
that's right, Your Honor.
He's picking those that come to Rosenberg. And the only link to Rosenberg is Rosenberg's own identity of them to him. Otherwise, it's corroborated because the money did go to Costa Rica and the Western Union and so forth. But we still have the failed link of courtroom evidence that Rosenberg gave to Quattlebaum. And that troubles me a little bit on those 8.
Agent Quattlebaum also testified that the case agents interviewed or attempted to interview all of the indictment count victims, and that that interview process validated the methodology. So it's not
just
hearsay
too.
Front end. No, Your Honor, I don't think so.
You mean you go to the victim and the victim says basically, yes, I spoke with Rosenberg, and the case agent comes in and said, okay, we have this case. The victim told me, and I hear an objection. I say sustained.
Well, right, Your Honor. Your Honor also mentioned that Agent Quattlebaum testified that he, from his knowledge, excluded some
his knowledge of other call centers.
That's right, Your Honor.
Which assumes that he had universal knowledge.
No, it doesn't. It doesn't assume universal knowledge. Remember, Your Honor, we're on the sufficiency review here, and
well, it's beyond a reasonable doubt.
Well, that's right, Your Honor. But the jury made that judgment that these substantive counts were connected to the scheme beyond a reasonable doubt. And on sufficiency review, this court isn't inquiring into whether
if the jury is sitting there hearing a witness say, Rosenberg told me A, B, and C were appropriately on the list, and I confirmed it by looking at Westinghouse, and I interviewed it, and the person said it was he was one of the payors to Rosenberg. Is any of that good? The jury heard it. The jury heard it and probably came to a verdict based on what they heard. But the question is that good evidence to support the conviction?
Well, Your Honor, we think it is. We think it wasn't premised on hearsay. And we think the fact that Quattlebaum and the other case agents were able to eliminate some of the counts based on their prior knowledge is itself admissible evidence that would support the jury's verdict and is substantial evidence. But I take the court's concern.
Okay.
And I understand the court's concern. And I think it's important to remember that the conspiracy counts here and the substantive counts that were directly connected through testimony survive that. And if I can, I'd like to address the over 55.
Are you inclined to confess error on any of these counts?
No, Your Honor, we're not.
Good for you.
I understand.
Confess error. Let's try it.
I understand the court's concern. Look, these cases are a bit difficult.
You said that you understand the concern, and you say the conspiracy counts clean, and some other counts are clean. Well,
That's right,
do you need to close? Why do you need those close?
Your Honor, candidly, I think Judge Cogburn in the district court, just speaking candidly, I think Judge Cogburn likely essentially said in the district court that he would have imposed the same sentence absent some of these substantive counts. So I understand the point. I would like, if I can, to address the remaining concerns that my co-counsel has identified. I'm sorry, my colleague on the other side has identified, including the over 55 enhancement. I think Judge Niemeyer's colloquy with my colleague, I think, got to the heart of that issue.
I expressed some difficulty with understanding why the enhancement under B9A should be imposed, because that enhancement requires the defendant to be the person misrepresenting himself as a government agent or a part of the government. And in this case, there's no evidence that the defendant misrepresent himself. The only way you get that is through some notion of Pinkerton or conspiracy, whatever. And I'm not sure that guideline allows for that in that particular context. That's a two-level.
That's right, Your Honor. Happy to address that. But if I can I just take a moment to explain why I think this is a uniquely persuasive situation for this court to identify harmless error. And that's because this error was actually, if there was an error here, which Judge Niemeyer, I think you're hypothesizing there might have been.
The court sort of said it's all irrelevant because I'm going to give him such a downward variance, and did.
Right. So there are three reasons.
And then says that's a variance I would do regardless of the calculations.
That's right.
I understand all that.
Yeah. Right. So I mean, the district court was crystal clear that this guidelines calculation was not going to affect the sentence that it imposed. So I don't think there's any concern about that. But on the merits, I think if this court were inclined to address the merits, it would force the court to resolve, I think, some tension between I think the intuition that Your Honor identified, which is also, I think, tracked in this court's decision in Moore regarding 3B1.3, and this court's decision in White, which is both of these cases are identified in our brief. So in White, this court holds that 1B1.3, these sort of vicarious liability theories that are encompassed in the relevant conduct guideline, applies to section 2B1.1B9A, such that at a minimum, the defendant, him or herself, need not make the representation, right? And the court's holding, I don't think, necessarily depends on the conclusion as to whether the defendant is misrepresenting him, whether the misrepresentation concerns the defendant, him or herself, or not. But the facts in that case, in White, the person who made the phone call identified himself as a government agent, and that was not the defendant. The defendant was the person who directed that person to make the phone call. And so that actually is quite similar to the circumstances here, where somebody else is identifying himself as the government agent, not the defendant. But this court held that 2B1.1B9A applies in that circumstance. Now, I very much understand the court's concern about the language of the guideline, the defendant. And this court's decision in Moore concerning 3B1.2 also relied on that language, the defendant, in holding that 1B1.3 didn't apply.
We do this also in drugs, even in conspiracy cases. We have a little bit of a different standard. We look for the evidence that's imputable, foreseeable to the particular defendant, even though it was foreseeable to the conspiracy, which is insufficient. So there are adjustments during sentencing and under the relevant conduct that.
That's right, Your Honor. And I'd like to explain, I think 2B1.1B9A is a particularly good example of a guideline where the relevant conduct 1B1.3 provision should apply. And that's because unlike 3B1.3, which is the abuse of trust guideline that was addressed in Moore, that guideline really depends on a relationship between the defendant and the victim. It's whether the defendant abused the trust that that victim placed in the defendant. By contrast here, for the misrepresentation as a government agent, the harm is exactly the same, whether or not it's Mr. Dot or another defendant who's the person who's representing themselves to be a government agent. The harm is precisely the same. And so I think 2B1.1b9a is actually quite a good candidate for applying the relevant conduct guideline. And so that's the government's position on 2B1.1b9a in this case. I'm happy to address any other questions the court may have, including the over 55 enhancement. But if the court doesn't have any further questions, we're happy to rest.
Judge King, you have anything more?
I'm in good shape.
Okay. Judge Cullen?
No, thank you.
Okay.
Thank you very much.
Thank you, Mr. King. Mr. Carpenter, give you some rebuttal now.
Thank you very much.
You promised to touch some of the sentencing aspects, and you're free to do that. And if we really get into a difficult question, we can bring Mr. Kane back. But I think we'll hear you first.
Okay. Thank you. I'll touch on sentencing. We'll start out there if that's okay. Specifically, the enhancements for misrepresenting a government agent. I think you're right, Judge Niemeyer. The plain language is pretty clear. It has to come from the defendant, and that didn't. There's no evidence that happened here.
But why don't you address the argument that the government makes, which is essentially that's like any other element of the offense. That there's a misrepresentation of the government by the conspiracy, and he's imputed with that wrong. Indeed, in this case, he knew that there was a misrepresentation of a judge. I don't know if that was a federal agent, but
I still think it's supported by the plain language here, or the commentary. I think the commentary would address that if that were part of if the relevant conduct part were relevant to that enhancement. And so I don't think you need to get away from the plain language here when it says the defendant has to be the one doing it when clearly he was not doing it. There's also two other sentencing enhancements that I want to talk about. The first being the minor participant 2L reduction that was not given. The comment to that particular sentencing guideline, if I may read briefly, comment 3A says that the reduction should apply if the loss amount greatly exceeds the defendant's personal gain from a fraud scheme or fraud offense, or if the defendant had limited knowledge of the scope of the scheme. We've already talked about that he didn't have full knowledge of everything that's going on. The personal gain part of it is applicable here. The testimony was that he received 3 cents a minute for his role in this for the phone lines, which Rosenberg testified was about $700 to $800 a month, depending on how much they used their phones that month. When you take the duration of the conspiracy at 40 months, you get $32,000 that Mr. Dot got throughout the conspiracy. The total conspiracy amount was $7 million that was found. That amount is 220 times the personal gain that Mr. Dot received from this. And so that's greatly.
Well, let me ask you this. I understand that argument. I think it's a good argument to make. The question I am troubled by is that this whole operation only works with the ability and a skill to be able to adopt and collect numbers, use different numbers to change numbers, to move locations, to reinstall phones. The whole operation is essential. That depends on it. Obviously, once you have the phone connections and perceptions of whether the FBI is tracing you and all that type of stuff, the more important part is probably the persuasiveness of the speakers in hooking the victims. But none of that could have taken place without this sophisticated technology. And so if a court were to conclude that the technology were very important to the conspiracy, how does that play with respect to what you were just arguing?
Sure.
Does that, what you are arguing, trump the fact that this co-conspirator was providing a very important part of the conspiracy?
Well, thank you. Let's talk about that. the argument the government presented their entire case on the idea that this is special technology that was used for this. Well, there's nothing special about this technology. Today, we're having this oral argument using VoIP services, using this technology.
But how many people know how to install a phone in Costa Rica, use voice over internet mechanisms, obtain a telephone line from Washington, D.C. or New York, 202 code or 212, and then be able to get numerous new phone numbers on a repeated basis without being discovered and knowing when the FBI is tracking. This I don't know. I would sort of admire that if I saw that.
Well, I understand you would, Your Honor, but
that doesn't say anything because I'm not of the current generation that are so computer smart. But with all due respect to Judge Cogburn, who I'm friends with, and I don't think he was familiar with it either. But there's nothing unique or uncommon about this. I think obviously there's nothing in the record to support me saying that, but I think you can take crucial notice of how common VoIP services are. I know that is, but I think the idea of setting this up, taking it down, setting it up with phone lines, getting phone lines in, or going over the internet, the signal is probably much more common, and a lot of people do that. But I'm thinking also, how do you get telephone numbers assigned to you and then abandon those numbers and get new numbers assigned? And if you keep going back to the same source, a little bit like the OxyContin, at some point there gets to be a suspicion. So you have to have, I don't know where you get those numbers from, whether they're a person makes a judgment, or you have to speak to somebody, or can you get it just by internet connection? I don't know.
I can call Verizon now and have them change my number. Anybody could do that. Verizon
does. If you change your number today and then tomorrow and then next week and then again next week, going to Verizon, would they keep giving you new numbers?
I would assume so. Are we putting a duty on Verizon to check those sort of things?
No, but it might raise question, wouldn't it?
Well, it might, but does that equal conspiracy or aiding and abetting of fraudulent activity? There's a slippery slope here that the government
was sophisticated enough to dodge
circumstantial evidence. That's all circumstantial evidence.
Yeah, I do want to answer the first question you asked. I know we're over time, but if I could do that real briefly.
Okay.
I would compare what Mr. Dott did. Sure, it was essential to the scheme, but so was the mail, so was Western Union. Magic Jack, the company that did this before him, they did the same thing. They were essential. They're not here they were not prosecuted. And this is the first prosecution of anybody like this the government's ever done. They prosecuted many of these schemes. They never prosecuted anybody who's provided these services before. And so this is.
Are you claiming an impermissible selective prosecution?
Certainly. I do question.
Are you claiming a constitutional deprivation by selective prosecution?
This is not argued in the brief or a district court, but certainly I think there's some questions.
What's your claim then? What's that got to do with this?
Okay. Well, I think it's important for the court to know that to have the context of what this case is all about. They prosecuted numerous of these. This is the first time that this has been prosecuted, and they made this very clear in sentencing. They're going to keep prosecuting these people who are helping out and providing phone services. And where does that?
This kind of stuff. I mean, that's what they ought to be doing, I would think. I mean, that's what prosecutors do. They try to weed out crime and put a stop to it. There's a thing called deterrence from prosecuting people.
Yeah, there's nothing wrong with this, but if you give them an opportunity to prosecute somebody who's just providing normal services, this is what he did for a living, was provide these services to Burger King, KFC, everybody, then the door is open to go after the Verizons or the other companies, or the other small guys who provide services that are used illegally. And that's the policy concerns underlying this whole appeal that I think the court should take into account and consider how this is going to affect future prosecutions and future case law. And I know I'm way over time. I did want to address harmless error on sentencing, but it looks like I'm out of time.
Thank you, Mr. Carpenter. I note that you were court appointed, and I want to give a special recognition for that. As you know, that's so important to our system, and you've done a fine job, and we appreciate your service very much. I'm sure your client does also. This time we would normally come down and shake your hands, and we can't do that today, but we do thank you for your arguments and welcome you to the Fourth Circuit. Hope you're both back many times. And with that, we'll proceed. We'll take a 5-minute recess based on age of the judges. Okay, will the clerk please get a short recess?
Thank you, Judge Niemeyer. The court will take a brief recess. The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit.
All right, we'll hear McCoy versus Correctional Officer Endicott et al. And start with Mr. Nessel.
Thanks, Your Honor. Thanks for having me. I appreciate it, and I hope everybody's having a good morning. This matter revolves around a case before Judge Chambers in the Southern District of West Virginia, Huntington Division. Basically, Ms. McCoy is requesting that this court reverse and remand this matter back to district court. And there's two errors, but they're pretty much intertwined, Justices. One of which is the court prematurely granted summary judgment at the lower level, and then again denying a motion to reconsider that. Now, the facts of this matter are, I'll be extremely brief. I know the court's armed with all
Mr. Mr. Nessel?
Yes, sir.
Mr. Nessel, this is Judge King. Do you have a final order here that's appealable?
Yes, sir.
Seems to me that the state claims are still pending.
Well, not in regard to
State law claims. You got 12 state law claims, or have
Yes, sir.
in
regard to the federal claims in 1983 action, Your Honor, those are all pending. Or excuse me, those are final.
The
what's
state
the
law
status
claims
of
have
the
been
state?
dismissed.
I
Your
beg
state
your
law
pardon.
claims have been dismissed.
Yes, this case has been dismissed completely. It granted
Well,
summary judgment on behalf of Mr.
You didn't ask for it to be. Nobody asked for it to be all the claims to be dismissed. They asked for the 1983 claim to be dismissed.
Right, but the court granted and dismissed this matter.
I think they're still. I think the state law claims are still pending, and I think you got a jurisdictional problem. But go ahead.
Okay. Well, I'm looking at the conclusion in Judge's August 13th, 2019.
Mr. Nessel, he doesn't address any of those state law claims unless you read the qualified immunity part of his opinion as dealing with, the West Virginia version of qualified immunity, and somehow impliedly that resolved the state law claims. I think he dealt with Kingsley and then he applied qualified immunity. So I think Judge King's absolutely right. What happened to these state law claims?
Well, I thought they were all dismissed according to the order.
Where's the order? What page?
Your Honor, it begins on page, hold on one moment, please. The judgment order is October, well, there's two orders. Should be 243 according to what I had.
That's
but
right.
I don't think.
And then reconsideration is 255.
Yes, sir. Well, I think there was a different appendix, Your Honor. 354 is the August 13th, 19 order. And then there's 366, which is October 3, and 372, which is the October 16, 2019 judgment order.
Mr.
You had
Nessel,
12 state law claims, right?
I beg your pardon, Judge King?
You had in your complaints, you had 12 state law claims.
I did.
8 tort claims and 4 state constitutional claims, I think.
Yes, sir.
And the only thing y'all litigated was the 1983 claim.
Well, that's right, Your Honor, and that's what this appeal is about, the 1983, which I believe is the most salient claim of
That's
the
right,
law.
but you got to have it. But you got to have a final order to get that reviewed, I think. But anyway.
Did the court dismiss the state claims?
The court dismissed the case, period.
No, I'm asking you the state claims. Is there any indication that the court disposed of, addressed the state claims?
Buying through qualified immunity, which you had just brought up.
but that's not clear.
But did the court address qualified immunity on all the state claims?
That's the way I read the order, yes, because it completely dismissed the matter.
It wasn't raised as to all the claims.
I believe it was, Your Honor.
It's somewhat ambiguous, isn't it?
Well, it seems that way.
I mean, Judge King's point, I suppose, is if if the motion is made with respect to one count, which is the 1983 count, and the court addresses that motion, and there's no motion made with respect to the state counts, and the court doesn't address the state counts, and then it purports to dismiss the whole case, what's the status?
Well, Your Honor, then it's dismissed. It was stricken from the docket up and until I filed my
No,
notice
but
of
that
appeal.
doesn't mean the state claims aren't there, or does it? Maybe they aren't there.
Well, they aren't. If Judge Chambers dismissed the whole case and struck this whole matter from the docket, then apparently he dismissed all claims, Your Honors.
We'll have to think about that unless you guys want to give me any more advice, and we'll ask your colleague when he's up about it too.
Okay.
Why don't you go on with your merits?
Thanks, Your Honor. Well, anyway,
I think generally we look at the substance, not the form, regardless of the label getting by the district court opinion. We look to see whether the district court adjudicated all the issues in the case. And if without that, there's no final order. That's in a case called Porter versus Zook, which is a Fourth Circuit case in 2015, 803 Fed 3rd 694. A mislabeling of the non-final judgment as final doesn't make it final.
Well, may I ask you something, Judge King?
Well, I don't normally come here to answer questions.
Yes, sir.
I usually come here to ask them, or I listen to the lawyers.
Yes, sir.
And my colleagues. But I'm just observing that you're going to have to get past this Porter versus Zook to make this a final order.
Well, I take this as a final order because when Judge Chambers entered it, it was stricken completely from his docket up and until I filed the notice of appeal. When I e-filed it, it said this case is closed. However, I had to go through, of course, the regular appellate.
Well, what if the appellee in this case said that the court words are a misnomer, that it never addressed the other counts? They were never brought on the table, never disposed of, never considered, and that the court, in dismissing the whole case, overlooked it, and they moved to dismiss the appeal on the basis of subject matter jurisdiction.
Well, if the appellee did that, Your Honor, then, I mean, if he argued that, then my response would be the same, is that I'm going on what Judge Chambers did. He dismissed this matter completely.
Well, we know, but I'm conceding he did that. The question is whether if that was error. What if he misspoke?
Well, if he misspoke, then I'd have to go before Judge Chambers again and see exactly what he admits, sir. I assume.
All right.
Maybe you could dismiss them while they're on appeal. I don't know.
Subject matter jurisdiction is something that we always can raise at any time, even after oral argument. Okay, why don't you make any other argument you want?
Okay, Your Honor, I'll proceed. Basically, the facts of this matter is that Ms. McCoy was an inmate at Western Regional Jail, which is run by the defendant, West Virginia Regional Jail Authority. On Tuesday, February 13th of 2018, she was in her cell having a diabetic seizure. One officer, Officer Ferguson, proceeded in her cell, and according to my client's sworn deposition testimony, began mocking her for it. Things transpired. There was an issue between Ms. Ferguson, the CO, and my client, Ms. McCoy, and so she was ordered out of her cell. The video clearly shows, and the video has been provided to the court, the video shows Ms. McCoy being complicit with the orders. She put her left hand and her right hand on the wall.
Just a minute. The prelude there, I don't know if it's relevant, but Ferguson says that she did call for a medical thing, but then she complained about being in that cell or in that pod or whatever and wanted out. And the video shows Ferguson trying to close the door and McCoy getting her way out. And then Ferguson sort of works her against the wall up to the corner where he has her up against the wall and she's called for help. Now, I don't know if that makes any difference, but the video clearly shows Ferguson trying to close the cell door while McCoy is getting out, pushing the door out to get out, which is consistent with the testimony of Ferguson, a statement of Ferguson. Ferguson's statement, as you know, is in one of those reports. She made a statement, and that's what her statement was.
Right.
But regardless, she's in the corner, and Ferguson said she's trying to give her some knee to get her to the ground, to get her in control. She has her hands up in the corner, and she calls for help. Two guards come in and take her down very quickly, one pulling the legs out, and the other said he used a arm. I don't know what that is, a straight arm method, and took her down to the ground. And of course, in doing so, she hit her head terribly on the concrete, which broke some bones. That's really, that makes the case really tough. But when you look at the video, it looks like the officers just came in quickly, took her down to the ground to get control of her, and escorted her out of the room.
May I?
Please respond. That's what I saw on the video.
Okay, well, Your Honor, there's a dispute between what Officer Ferguson and my client state. My client state.
Oh, no, tell me what the video showed to you, and then you can go back to that. But I'd like to get some agreement as to what we're looking at in the video.
Well, yes. Okay, I will agree with you on that, Your Honor. Now, okay. Yes, but the point in the issues with Ferguson, her mocking my client in that cell, according to my client's sworn testimony, and Ms. Ferguson, Officer Ferguson, wasn't under oath when she gave her written statement, but nevertheless, but I'll go with what the court had asked. When Ms. McCoy was outside, she was out there and she was on the wall. As testified by both Hale and Endicott, the boots stomping in that empty cell pod, and the court has seen it, makes a very loud echo. Upon hearing that, my client turns to her left. These two individual officers, what they did was bypass various steps and went straight to deadly force. The deadly force as defined by their employer. Now, of course,
just a minute. Would you say that using the force necessary to take somebody down, which an officer learns when they do any kind of arrest or taking somebody under control, is that deadly force, or is it deadly force simply because what happened as a result of the fall was very serious?
Well, the definition of deadly force, according to the West Virginia Regional Jail Authority, is that a broken bone or making an organ inoperable. So basically, the broken bones, which my client had, when she hit, and as you noted, Judge Nehemiah, when Ms. McCoy hit on the floor on the right side, the force was so bad it not only broke that part of her mandible, but the other side, that's where the significance was. That's the broken bones. And then in regard to loss of an organ, it ruptured her ear.
But Mr. Nessel, it turns out in this case, and the injuries were severe, but that doesn't determine whether or not the arm bar and the leg sweep constituted in and of itself deadly force. You're looking at the outcome. Let me ask you this 1+1 policy that you cite, which I think the court can consider, it doesn't set the standard, but it informs as to whether or not the use of force was reasonable. As I understand it, the officer can take one level beyond in order to maintain control. So where was Ms. McCoy on that continuum? In response, what did the officers do? I think I know the answer to the second question.
Well, the options, Your Honor, and it was testified to by at least one of the officers. The options, as you mentioned, it's officer presence, that's the person being there. Verbal direction, that could have been used. Empty hand control.
We're beyond that. I mean, she broke out of her cell. She was engaged in a struggle with a correctional officer in the middle of the pod. You had somebody approaching another inmate. I don't know what she was going to do, but that's a serious security breach. I think you're at intermediate at a minimum, aren't you?
No, I think what we are is, yes, I think we're at intermediate at that point, but I would argue that would be the third one, which is C. They went straight to picking her up and body slamming her, Your Honor, and that's what caused these severe injuries, permanent injuries. Now, I understand what the court's saying, Judge Collin, but what I am arguing is that as they testified in their depositions, yes, they could have done something else, simply put their hands behind her back. They have the zip ties. They could have secured her that way. These are two grown men who work out. They are around 6 foot, 240 pounds. My client is about 5'7", about 165 at the time. What they could have done and what they should have done, according to their employer, and quite frankly, in their deposition transcripts, what they could have done and should have done, there are two of them. One of them grabbed each arm, placed them behind her back. That's all they should have done. That would have secured her to no end whatsoever. And in addition, Officer Ferguson was there. What they did, Hale and Endicott, was went straight to the most dramatic thing possible, picking her up and body slamming her, crushing her head, suffering a concussion, rupturing an eardrum, and breaking her mandible. They easily could have put her arms behind her back, but they did not. She was against the wall. She was not flailing. Witness statements state the same. And I see my time is up on this.
Yep. Okay, thank you.
Thank you, sir. I'll mute.
Mr. Murray?
Yes, Judge, may it please the court. My name is Bill Murray, and as you know, I'm here today representing Officers Endicott and Hale. We are asking the court to uphold and affirm the lower court's ruling that the force that was used in this incident was objectively reasonable, which is the standard by which this case is judged. The main thing we have in this case, which as Mr. Nessel knows, because he and I have had many cases together, we don't often have the luxury of having video evidence. However, in this case, we do have the video evidence. And the video evidence is clear and to some extent disputes Mr. Nessel's characterizations of it. But what it shows, and Judge Niemeyer, you were correct, we don't necessarily get into what happened between Ferguson and McCoy prior to the officers entering the room. They were out in the jail. They got a call for officer assistance. When they come through the door, as Judge Cullen has pointed out, they are faced with a hands-on incident with an inmate and an officer in a corner. You have two other inmates that are loose, one of who has moved very, very closely to them. Now, we don't know whether or not she was going to get involved in any way. We have no way of knowing that. But it really doesn't matter because the perception is to the officers, this is what's going on. They are trained to take control of a situation. And they move in, what they have to do is they have to get control of this inmate who is struggling and in an altercation with another inmate, and that's what they do. From the time they enter that section to the time of the takedown is all of 7 seconds. Mr. Nessel would argue, well, they could have done other things. They could have done this. They should have done that. But we don't go back and look with 2020 hindsight in this instance. As the Kingley versus Hendrickson cases pointed out, we take the officers at the very moment that they act. What do they see? What do they perceive? And Judge Niemeyer, the straight arm bar takedown that you referred to, that is a technique which is used and which is trained where you take the wrist, you pull the arm straight, you put pressure down on the elbow and you push down, and that forces the person to the floor. That's what they're supposed to do. The fact that unfortunately in this case, a severe injury occurred does not make that use of force deadly force.
Does it usually occur simultaneously with someone else taking out the legs? I mean, how did that come about based on the record, and did that kind of compound the problem?
He was grabbing at her legs to try to get hold of her. He didn't do the sweep the video shows as was alleged, but he was trying to grab a hold of her. At the same time, Mr. Endicott did this armbar takedown and she went down. But that's what they're taught to do, is get these people on the floor, on their stomach, control the head, so then you can get control of the whole body and the situation. And that's all they did.
Is that deadly force?
It is not, Your Honor.
Why not?
Deadly force is defined as force which is likely to cause death or a serious bodily injury. Now, when you're dealing with a jail setting, we're dealing with a place that is constructed primarily of concrete, steel, and cinder blocks. And unfortunately, when people go down, sometimes they get hurt. I've seen lots of them. You'll end up with bruises, possibly cuts or laceration, but it's not likely anytime you take down that you're going to injure an organ or that you're going to cause a broken bone. This just happened to result. And the fact that it did result doesn't necessarily make it deadly force. Further, we also know that from the Whitley case and all, that when we look at the different factors to be assessed, the severity of the injury occurred is only one of several factors. One of the factors is the need to restore the security and the discipline to the section at that time. In this case, as has been pointed out, as the video clearly shows, they're faced with 2 additional inmates who were out in, one who was getting close. So what they did, again, we look at it at their moment. They came in, they were faced with this situation. They took control, they took her down to the floor, they got control of her. Again, we all agree, no one disagrees. It was unfortunate that she suffered those sorts of injuries, but those injuries in and of themselves, just because they happen, don't make it deadly force, because that was not the intent, that was not the likelihood of, if we take her down, she's gonna have broken bones. There is no serious likelihood of that. I would point out also, the plaintiff has produced no expert testimony that would say that this technique and what they did was improper given their training. They have to get control of the situation, and that's what they did. And the video is very clear on what happened, on how it was happening, what they were faced with. And based on that video, we believe that it is clear that the objective reasonableness, which is the test, that those actions were reasonable at that time, and that the granting of the motion for summary judgment should be affirmed.
Could you address the issue raised by Judge King, the jurisdictional question?
Yes, I can. And Judge King, I sort of looked at that myself at one point, but the way I read.
Why did you move to dismiss the appeal?
Well, because the way I read the original order granting the motion for summary judgment, Judge Chambers addressed the 1983 and the reasonableness and went through all the standards and granted it on that. He then went ahead and spoke generally in his order about the qualified immunity. Now, I may be right or may be wrong, but when I read that, I took that as him then granting these two individuals qualified immunity on the remainders of the counts because there had been no constitutional violation. Therefore, they would be entitled to qualified immunity on these negligence counts.
You think qualified immunity took out all the state claims, do you?
Yes, Judge King. That was my impression. And then there were also some state claims against the division of
qualified immunity doesn't take out all the state claims, and they're still in this case.
That would be true. Yes, that would be true.
In that case, there's no jurisdiction because it's not a final order.
That would be true. Yes, and again, and maybe I was incorrect, Judge. And when I read it, but when I read the order granting the summary judgment, I read that qualified immunity section, which was the second part of that order, as dealing with the state claims as related to these individuals. Now, maybe I was wrong in reading it that way, but that was the way that I read it. The remaining state claims against Ferguson and against the Regional Jail and Correctional Facility Authority, those were subsequently dismissed voluntarily by Mr. Nessel, so those are no longer around.
But Mr. Murray, on that point, I mean, you would acknowledge, and we're talking about qualified immunity, we're really, in this case, talking about they overlap, and the state standard is coextensive with the federal standard, but you would have to look at the state qualified immunity and analyze that in addressing the state claims. And as I read this one paragraph, I can't tell if this is an alternative holding on the 1983 claim, the Kingsley claim. Even if it was a violation, they'd be entitled to qualified immunity under the federal standard, or if it's what you're arguing, that under West Virginia, that doctrine, which is very similar, that takes care of the state claims. He doesn't specifically mention the state claims at all or specify which doctrine he's talking about.
I agree, Judge Cullen, that is true. But the interaction between the federal qualified immunity standards and our state qualified immunity standards are virtually the same. And in fact, our Supreme Court has said we look to the federal law on qualified immunity to determine how it works. And again,
But that might not dispose of all of the state law claims, right? I mean, it just depends on what the claim is, what the elements are. Qualified immunity may be available, it may not. I guess it just leaves us guessing as to exactly what he meant and how it applied.
And I would agree with that at this point. Again, my interpretation was that he got rid of all the rest of the claims against these officers based on the qualified immunity, but maybe I read it wrong. That was my interpretation of it at the time.
Your position is that we have jurisdiction?
My position is that you have jurisdiction, that the state law claims were disposed of, and that this case, and that the final order that was entered by Judge King on October the 16th took care of everything, and this case is over unless you remand it back.
All right. Thank you, Mr. Murray. Mr. Nessel? You're muted. You'll have to unmute.
I do that all the time, Your Honor. I apologize.
That's all right.
Thank you. Thank you for allowing me to proceed. I appreciate it. Now, Mr. Murray's right. They have to make a split decision. Every officer does because of the circumstances, be it a correctional or a police officer. But I'm going to go back to what I had stated earlier regarding the respondent Endicott. Now, I said this is on page 12 of my opening brief. If an inmate is against the wall, wouldn't the proper use of force be that the third one, C3, empty hand control? Then he defined against the wall. And I said that would be restraining an inmate. And he said, yes. He agreed that that was the proper remedy they should have done. That goes back to what Judge Collin had asked of me. Now, that takes care of that issue. Now, another thing has been made about what deadly force is. I did not draft the jail authorities' definitions of what is what. However, in statement document number 9031, it defines deadly force as, quote, force which will likely cause death or serious bodily injury. It defines serious bodily injury as, quote, injury which creates a serious likelihood of death or major disfigurement to include broken bones, loss of limb, paralysis, or the impairment of the function of any bodily member organ. That is what happened here. We can play semantics all we want, as I stated in my reply brief, but according to what the jail authority had written, these are their lawyers, they have a team of them. They stated that what happened to Ms. McCoy was in fact deadly force, which would be that E5 category. So that's where we stand on that. Now I understand, again, what we're discussing here is what they could have done. Again, Endicott and Hale agreed they could have just put their hands behind their back, as I showed, and I know Judge King can't see me because he doesn't have the video, but as their hands were behind their back.
For Judge King's purposes, you've got your hands behind your back.
Yes, sir. And all they had to do, her hands are up here, and I did that. If you look at my opening brief, it says counsel's indicating, because I had left hand, right hand against the wall, put one back, the left, put the other back, because there's two officers. Again, this is a slight woman. These individuals, as I stated in my beginning argument, these guys weren't small. Endicott, 6 feet tall, 210 and lifts weights. Hale, 6'1", 240 pounds, and he also works out. I'm not saying Ms. McCoy was a slight woman. She's 5'7", about 165 pounds, but you have two big, burly individuals who testified, judges, justices. They testified that, yes, they could have used a different form of restraint. They did not. Ergo, that's excessive force.
Okay, is that it?
Let me just make sure, Your Honor. And by the way, Respondent Hale, he actually apologized to my client. That denotes an admission of not guilt, because this is not a criminal matter, but of some liability. He disputes that. My client disputed that as well. They could have done a lot of things. However, they didn't. Now, I believe that my brief and the evidence here speaks for itself, and I believe the argument clearing things up. And I agree with Mr. Murray that, yes, this court does have jurisdiction. So if there's no further questions, I truly appreciate your time. Thank you.
Thank you, Mr. Nessel.
Yes, sir.
Thank you both for your arguments. Our practice, as I don't know if you've heard earlier, is to come down, you both know, is to shake hands. It's one of those practices that's iconic to our circuit. No other court does that I'm aware of. And we enjoy doing that. And we thank you for your arguments and greet you and hope you have a good day and whatever. And so the best we can do is what we're doing right now. And thank you. And we'll see you back in court, we hope, soon.
I hope so too.
Yeah. All right.
Justices, have a great weekend. Bill, nice seeing you.
You
Thank
too,
you for
Terry.
both
We'll
of you.
see. Thank you,
Yeah.
judges.
Take care. Thank you.
Take care.
Good to have you.
Yes, sir.
Okay, we'll move on to the last case. First.
Yes, sir. Thank you. Good morning, and may it please the court. My name is Marshall Ellis, and I represent the appellant in this matter, Lanier Moses. The issue in this case is whether Section 1B1.3's application note 5C is controlling and entitled to our deference after the Supreme Court's 2019 decision in Kaiser versus Wilkie. Here, the district court specifically relied upon application note 5C to count as a prior conviction for a controlled substance offense under the career offender guideline, a 2013 North Carolina.
Let me get the structure here so we're talking about the same thing.
Yes, sir.
We have a 2013 offense for which Mr. Moses was convicted and sentenced and served time. And then we have a 2018 offense of similar kind, which is at hand here. And your argument is that the two offenses are, that the 13 offense is relevant conduct for the current offense.
That's correct, Your Honor.
And even though the interruption is there.
That's correct, Your Honor. Because I don't believe that the interruption is necessarily dispositive under the guidelines framework that were offered in 1B1.3A2. And that's
so under your theory, we'd go back, we could get a 2011 drug distribution count, 2006, and count it all as relevant conduct instead of prior offenses, even though even though he is sentenced and convicted for the prior conduct, which I suppose is a conviction, counts as a conviction, doesn't it?
Well, it's a conviction, but just because it's a conviction, that doesn't mean it counts as criminal history. Criminal history is all.
No, I'm talking about relevant conduct, not criminal history.
Right. So I essentially saying the conviction itself is not what carries the day in the analysis. It's the conduct underlying the conviction, which 1B1.3A2 is looking at. And that's why
anything that's relevant conduct cannot be considered a conviction under your argument.
Anything that's relevant conduct. Well, my argument is that the conviction does not necessarily matter. It's about.
Well, right. You're saying this was counted. This 2013 conviction was counted in order to enhance the sentence, and it was counted as a conviction. And your argument is that it should not be counted because the conduct underlying that conviction was relevant conduct to the current conviction.
That's correct, Your Honor.
Okay.
Yes, sir. Yes. Essentially, the district court in this case made that decision that it is criminal history rather than relevant conduct, solely relying upon application note 5C. And because of the Supreme Court's 2019 decision in Kaiser, that particular application note is not entitled to our deference, and the district court was wrong to rely upon that particular application note. So
you agree that if we apply the guidelines and the commentary, then your argument is foreclosed because of 5C, right?
That's correct. If 5C is going here, I lose. I would not deny that, Your Honor. Yes, sir.
All right. So you want us to overlook 5C, which explains how to do relevant conduct.
I want this court to not give it our deference. And I essentially am saying that that particular application note is not interpreting the terms.
So in Stinson, the Supreme Court said that the guidelines, the policy statements, and the commentary are all have the force of law. And the only time that we look away from the commentary is when it's inconsistent with the guideline in the sense that both cannot be enforced. That's what Stinson said.
That's true as to what Stinson
And so you're saying Kaiser overruled Stinson.
I think Kaiser says what Stinson meant to say all along.
Well,
That's what
except in Stinson, you remember the court spent a lot of time talking about the nature of the guidelines. The commission did the commentary to explain the policy statements, and they gave them all the force of law, and they didn't talk about ambiguities. They talked about inconsistency, and they gave that a narrow interpretation because of the nature of the commission and the guidelines. And while it's analogous to an agency, they did not require there be an ambiguity in the guideline in order to apply the commentary. If that were so, we would not be able to apply the commentary in most of our guideline applications because the guidelines are almost always ambiguous. The commentary explains them and talks about how they're to be applied. The question is, I know you rely on Kaiser, and Kaiser gives you a lot of help in the agency context, but the question is, Kaiser didn't purport to overrule Stinson, did it?
Kaiser did not overrule Stinson. Again, I think Kaiser essentially is saying what Stinson meant to say all along. So,
so they misspoke in Stinson.
I'm not saying they necessarily misspoke. I'm saying they didn't quite say everything they meant to say as to that particular issue in that case.
They said a lot.
So, right.
They discussed the relationship between the commentary and the guidelines at length. They explained the nature, the force it was carrying, the policy statements. They had an earlier opinion that said policy statements carry the force of law. I understand your position. Yeah.
Yes, sir. And essentially that is my position, is that Kaiser is changing the analysis that Stinson once gave us with respect to guidelines commentary.
Mr. Ellis, let me ask you this. Let's set aside 5C. All right, let's take it out of the analysis. You don't want us to consider that. You consider that just an arbitrary rule. Otherwise, Mr. Moses' 2013, under your argument, is going to count as relevant conduct under 1B 1.13A2. Okay. And I think you make two arguments. First thing you say is, well, the government waived any argument that there's no evidence that the 2013 and the 2018 are part of the same common scheme or plan or same course of conduct, because they didn't raise that at sentencing. And then the corollary to that is you say we can look at this PSR and conclude that the 2013, the 2018 are part of a common scheme or plan or the same course of conduct. I've looked hard at this PSR and I'm having a hard time finding evidence that's undisputed that would satisfy either one of those, whether common scheme or plan or same course of conduct. If you're talking about same course of conduct, single episode, spree, regularity, you've got 5 years and 1 month between the 2013 and the 2018. So I don't think that fits. I think you're arguing common scheme or plan. And you make this argument, well, all of these distributions occurred in this Bragg Street neighborhood. That's not in the PSR. All we know is that he dealt a small amount of crack in 2013 in Raleigh and Wake County, and he did the same in 2018. You also ask us to infer that he did these things in order to support himself. He's a low-level drug distributor, and that's what we should infer. Why should we infer that? I mean, the PSR also says he's a member of the 9 Trey Bloods. I mean, how do we know that in 2013 he wasn't dealing for the gang and then 2018 he was supporting himself? So point me to specific evidence in the PSR that supports your argument, set aside 5C, that you have satisfied that.
I understand the court's concern completely. And essentially what I think I've done here is possibly made a mistake in my briefs and even arguing that, because I think what we're getting at right now is a task that's best left to the district court to make factual findings and conduct the appropriate legal analysis under 1B 1.3A2 and then application note 5B. That's not a task for this court to do, and I was wrong, in my opinion, to even suggest that it was in my briefs. So I think we're getting ahead of ourselves with your question as to what specific factors there are in facts, I should say, there are in the PSR that support same course of conduct or common scheme or plan. I think that's
so you're conceding that there isn't sufficient evidence. We can't reach that. You have established that if we rule in your favor on the 5C, it has to go back.
I'm saying it has to go back for further factual findings by the district court as to that particular question you were asking.
Well, let me ask you this. This is a little puzzling to me, what you're asking. The pre-sentence report lists a conviction in 2013. He served 3.5 years. He got sentenced and had a conviction. So now he's no longer distributing drugs while he's in prison. The court counted that conviction as a predicate offense for career offender. As the career offender statute allows, any prior conviction that's of that a drug type. And you're saying we shouldn't count it. And then you're saying, but we have a question of fact. We should send it back to decide whether it's a common scheme.
That's correct, Your Honor. That is exactly what I'm asking you to do.
Why isn't it a prior conviction and satisfies the career offender enhancement?
It's not. Well, I think that would be something that's left to the district court to determine based on,
Except the pre-sentence report pointed out there was a conviction, there was a sentence, and he served the time.
That's right.
And so we have, under the definitions of the enhancement, which is career offender enhancement, we have a prior conviction, don't we? There's no question we have a prior conviction.
I would disagree because, again, when you're looking at what is a prior,
that's not a conviction.
I'm not saying it's not a conviction. I'm saying
well, that's what the enhancement requires. In other words, we don't even need to get under the other stuff. We just go to the career offender enhancement and say, does it satisfy the face of that enhancement?
So when you look at the career
4B 1.1.
Yes, sir. And then 4B 1.2 tells you what is a prior sentence of imprisonment for purposes of 4B 1.1. 4B 1.2 says that a prior sentence of imprisonment has to do with calculating sentences based on Chapter 4A of the guidelines. And that's where the 1B 1.3A2 comes into play, and with respect to my argument, because it's not necessarily the conviction itself that matters. It's whether it's a prior sentence under Chapter 4B Section 4A 1.2, Your Honor.
And you don't think it's a prior sentence?
I do not think it's a prior sentence.
Well, what was he doing in jail?
Your Honor, I don't think that
he spent 3.5 years in jail.
The time in jail is not dispositive. And I think there was an 11th Circuit case that I cited in my brief that specifically referenced that said that even though the defendant had served time in jail in between two separate acts that actually involved two different modus operandis, they were still relevant conduct to each other, even though he had spent time in jail. So that's what I'm getting at.
When the court convicts somebody and imposes a sentence and he serves time, we don't call it a conviction and sentence.
I'm not saying you don't call it a conviction and sentence. I'm saying it's not necessarily a prior sentence of imprisonment under sentences, and trying to assess whether they're relevant to each other under 1B 1.3A2. And you can go through the analysis under section, or I should say application note 5B, and determine that they are related, because 5B is sort of the classic interpretive guideline commentary that's giving you specific factors to consider, specific definitions of what the terms mean. It's not dictating a result. It's just telling you how to apply the guideline. So you can come to one result under 5B only to then keep reading right beneath it and get to 5C and be required to completely reverse the decision that you just reached under 5B. And that's essentially what I'm getting at.
In your argument, Mr. Ellis, there would be whether it's our or Stinson, even under Stinson, it's inconsistent with, because it essentially draws an arbitrary line. Let me ask you this. You cite three cases, the Shell case, Havis, and Riccardi, all right? And these are cases where the Sixth Circuit, in one case, the Fourth Circuit, I believe in Riccardi, they applied our deference. The others are Stinson cases. But all those cases held that the commentary was inconsistent, and the guideline provision couldn't bear the weight of the commentary. So the commentary goes. But aren't those cases different in that in Shell, they were adding to the definition of a crime of violence, forcible sex offense. In Havis, adding an attempt definition to a controlled substance offense. Riccardi, it was essentially setting an arbitrary loss amount for use of access device at $500, regardless of how much the loss actually was. As I understand the court's concern in those cases, it was that the commentary was broadening the scope of the guideline to sweep in more potential criminal conduct, whereas here it's restrictive right? And arguably it's protective to everyone but career offenders, granted. So respond to that. These cases are different, and does the fact that it's restricted matter and undermine your argument?
I totally agree that they are a little bit of a different nuance to the issue, but at the end of the day, they're all involving the same problem. So in Havis and all the other inchoate offense cases, you have essentially the guidelines setting a general standard. That is, what does the term controlled substance offense means? In Riccardi, you have the same thing happening, except it's not saying what the term controlled substance offense means, it's saying what the term loss means. In this case, you have the guideline itself saying that when calculating the offense level, consider all other acts that were part of the same course of conduct or a common scheme or plan as the offense of conviction. And then in this case, as well as in the others, you have the problematic commentary in each case, changing the outcome that you would have reached if you were left with that text alone and other interpretive commentary. So that's what I think the issue is here, is that the problematic commentary is changing the outcome. And
well, wouldn't common sense say that if somebody was dealing drugs in a neighborhood and got convicted and sentenced and was removed from the neighborhood for 3 years and then came back to the neighborhood and did it again, would you call that the same course of conduct under any kind of common sense?
I think you could, Your Honor, if the other evidentiary factors were there, like whether it was part of the same, or whether it involved the same area, whether it involved the same drug.
Yeah, he did the same stuff. He knows the area, he did the same stuff, but why isn't it another conviction? In other words, why isn't it a new conduct that's, again, violating the law in the same way? Okay, but I understand what you're arguing. Why don't we hear from Mr. Bragdon?
Yes, sir.
You're muted, yeah.
Good morning, may it please the court. My name is David Bragdon and I represent the United States. I'd like to start by taking issue with one factual thing that the defendant said, and that is, I think the court did not specifically rely on commentary 5C. And so the court's judgment is at page 111, and it appears to be a factual determination by the court that even if this is the same general area that drugs is being sold, it's not part of the course of conduct. And so I think the court can rule in our favor for either of two reasons, either because it finds that commentary note 5C is valid, or because it finds that regardless of that, this is not the same course of conduct or common scheme or plan. I do think that, with respect to note 5C, I understand the defendant's argument to be that if this is relevant conduct, then under the various application notes under Chapter 4, that means it can't also be a conviction that counts. So it's got to be one or the other. It's either got to be relevant conduct or a counting conviction. We don't disagree with that. And so then the question is, well, is application note 5C a correct interpretation of what this means? And this is an application note that's been around for about 30 years. In November, it'll be 30 years. It's never been questioned or thrown out by any court. And I think it does conduct a very reasonable balance as to where to draw the line of what counts. Because the whole purpose of this application note is to prevent double counting of conduct the defendant was previously convicted and sentenced on. And so if this application note is thrown out, a defendant could get a conviction, get sentenced for that, maybe for a very long sentence. He could then be convicted again, and that conduct that he already received a sentence for could serve as the basis for a higher guideline range. And while that might help this defendant and some career offender defendants, in general, that's a rule that's not going to be helpful or fair to most defendants.
I think Mr. Bragdon, Mr. Ellis makes the argument that may be all fine and well as a matter of policy. but shouldn't that then be part of the guideline itself? In other words, it serves an important purpose, and I take your point. But what about that, right? Should be part of the normal course of notice and comment. If you want to do that, do it the right way.
So then I think we have to ask the question of, well, is that a reasonable interpretation of the guideline, or is it something that's inconsistent with it? And I do not think that rule is inconsistent with the language. And if we focus on course of conduct, common scheme, or plan, these are broad, ambiguous words. And so when we start asking, well, can a conviction you've already been sentenced on be part of the same course of conduct or common scheme or plan? I think the general answer I would think of to that is no. A conviction you've already been sentenced on seems like it wouldn't be part of the same course of conduct or common scheme or plan.
And maybe Mr. Moses isn't a good test case, right? And I think Mr. Ellis might concede that, he might not. But can't you envision a scenario where, somebody's in a conspiracy, there's a state conviction, he's in jail for one day, he gets out, and he's right back in doing the same things in the same area with the same accomplices?
Yes. So maybe that does present a closer case. And I know that the government has taken the position in the past that, for instance, conduct that proceed, if there's a conviction in the middle, say, the defendant is, part of some illegal conspiracy, he gets convicted, and then he continues the illegal conspiracy, but the conviction and the sentence is for something different. We sometimes take the position of, well, you may have gone to jail for 30 days or 60 days, but this is still one scheme overall. But I think that still begs the question of, does that specific conviction that you've gotten a sentence for, is that going to be counted? And I think the fact that that the defendant has received a sentence for that does separate it in a way that maybe just a short stint in jail or a conviction with a suspended sentence doesn't. And I think that both Kaiser and Stenson allow agencies some degree of policy discretion. They know that the agency understands the regulation better. They know that they understand the purposes and the reasons behind it better. And so the agency then gets to say, well, this is going to be much more logically in line with the purpose and the basis of the rule. And so when you have an ambiguous rule like you do here, and you have an interpretation of that fits very well within the purpose of the rule, I think this court should give that discretion unless it's inconsistent. And I don't see it as being inconsistent here. So I think that's a lot of our argument. I think I will say just a couple more things on the 5C rule. This court multiple times has applied that rule. It's been in unpublished decisions. The Second Circuit, in a published decision, applied the rule and kind of explained the purpose behind it. No court has struck down or questioned the validity of 5C. And it also fits with this general idea. I think we put in the language of, we put in there one of the purpose, when they were thinking about this rule, they were thinking about it as being similar to the joinder provision, where you join, counts in one indictment. And again, that presumes the idea, well, you're not going to join a count in an indictment if there's already been a conviction for it. And that's a little bit of legislative history, because it's something that one of the authors of the sentencing guidelines put in an article. It's not part of the guidelines itself. But I think when we look at the guidelines as a whole, this fits very neatly with the structure. There's a rigid separation between relevant conduct, what's counting for the offense, and on the other hand, the criminal history. And the defendant's throwing out of this rule would merge those things together. And so I think that's what we would say. I do not think I need to add anything else as far as our arguments on the merits as to why this is not course of conduct or common scheme or plan, but I'll answer any questions the court has. Otherwise, I'll rest on our briefs.
All right. Thank you, Mr. Bragdon. Mr. Ellis, you have some rebuttal.
Yes, sir. Thank you very much. And thank you, Mr. Bragdon. As far as the contention here that the district court did not specifically rely upon application note 5C, I think that's wrong. Mr. Bragdon pointed you out to page 111, but you have to read page 111 of the joint appendix in conjunction with what came before it. And that's where on page 104, the district court specifically asked me at sentencing. So you're saying I should disregard application note 5C. And I, of course, said yes. She then said, let me go to the government now. Do you agree I should ignore note 5C? So when you read that in conjunction with page 111, I think it's really clear here that 5C is the underpinning of the district court's decision. And it's that which ultimately led her to overrule my objection and to sentence Mr. Moses as a career offender. Moving on then to the government's claim that 5C, again, I've heard multiple times that they're saying that 5C is an interpretation of the language of 1B1.3A2, and I just think that's not correct. I think 5C is not an interpretation. 5C is essentially a legislative policy rule on the part of the Sentencing Commission. And they are, you know, the hidden thing here is the Sentencing Commission, I'm not saying they're not free to make this rule. They just have to do it through the notice and comment rulemaking process by including this rule in the actual guideline text itself and not the commentary.
Well, it went through the whole notice and commentary, didn't it? I mean, the whole process was put together as a package, and I don't know if you'd call it an agency. Their role is analogous to an agency, but they really are a strange body in our constitutional structure. I mean, here you have Congress committing to this commission a broad range of authority under 994H, and this body created a federal judges coming creating this body of law, and they created it as a package. So it wasn't it was structured in such a fashion that they would give you the general rule and then they give you the explanation, and they would also distinguish between the general rule and a policy statement. So that's what Stinson tried to address. I think, and Kaiser, of course, is not even in the guidelines context. It's in a different one, but it did address our deference, as you pointed out.
Right, and the Kaiser opinion does make mention of Stinson.
Yeah, they have it in a list. Yeah,
right. Exactly. So I think that's a good segue then to let's get right to the issue here as far as step 1 through 3. And the text here, we all agree, is same course of conduct, common scheme or plan. That's the guideline text we're looking at. We have to first ask whether that's ambiguous or not. It sounds like we're both agreeing that it is ambiguous. If it's ambiguous, we can then look to the commentary for potential guidance, not automatic guidance, but potential guidance. And that last part is where we're disagreeing here. We are saying that application note 5C is not a reasonable interpretation of 1B1.3A2. We're saying it's essentially a legislative rule that's effectively just an exception to the general rule, much the same as it was in Riccardi with respect to the gift cards. That was, the loss amount for the gift cards. In Riccardi, it was, the guideline or the application note for 2B1.1 tells you what loss means and how it's the greater of actual or intended loss. And then it gets all the way to part F of that particular application note where it says special rules. That's essentially the same thing we've got here. And that's why we'd ultimately be asking the court to do exactly what Riccardi did and say that 5C cannot receive our deference. I did want to briefly address the government's essentially argument that what drastic effect is this going to have for other defendants? I think it's wrong to do that, because these should always be case-by-case determinations. It obviously helps Mr. Moses here. And to the concern that it might hurt a potential defendant in the future, let's remember that the guidelines do give defendants the potential to get credit towards their federal sentence for any sentences imposed that were part of the relevant conduct in this case. And that specifically comes from guideline sections 5G 1.3 and 5K 2.23. I don't want the court to lose track of that the guidelines do account for giving defendants credit for sentences that have already been served that are related conduct. And as to the potential effect here or the claim that Moses isn't a good test case, I would not concede that. I just think we don't have enough of a record here from the district court to definitively say that right now. And again, she made her decision based on application note 5C, and we're asking for this case to be remanded with specific instructions to make further findings without reliance on 5C. And I see I'm out of time. Thank you very much.
Thank you, Mr. Ellis. I know you're court appointed. I'd like to recognize your service and our appreciation for your service. You did a fine job. As a matter of fact, this is an interesting point, and you obviously have explored it at some depth. We also welcome again Mr. Bragdon and his argument. We normally would come down and shake your hands. We're going to have to use this greeting and our appreciation for your arguments as a substitute. But I know we'll see you both many times. Hence, as long as this pandemic gets under control, somebody needs to help us there. But thanks a lot, and have a good day. We'll adjourn court till this afternoon.
Thank you very much. It was a pleasure.
Thank you.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.
We'll take a 5-minute recess.